For the last topic, we want to look at excuses for non-performance. We mentioned that the CISG recognized several legal excuses for the failure to perform. The primary exemption for the failure to perform is found in CISG Article 79, which says that a party is not liable for the failure to perform any obligations if that failure was due to impediments beyond control. Impediments beyond control is the term of art that we use in the CISG. Now, in the common law here in the U.S., we generally think of this as the notion of impracticability, meaning it was commercially impracticable, which is not impossible, but almost impossible, in order for the person to follow through with the contract. It was impracticable. There was an impediment beyond the control of the breaching party that caused the breach. For instance, a court case a couple years ago out of Houston involved a company that had leased a restaurant for use, leased an area for use as a restaurant. And in fact, the lease required that the party have a restaurant in those premises and no other type of venue. Well, it turned out that unknown to either the landlord or the tenant, the restaurant area could not obtain a liquor license because it was too close to a school. So the restaurant was faced with the decision of whether to open, never being able to serve liquor, or whether to breach the lease. They breached the lease, they were sued by the landlord, and they cited the excuse of impracticability. And it's the same as the CISG. This is an impediment beyond the control of the breaching party, and therefore that should serve as a legal excuse for non-performance. Now, in order for this excuse to apply, there's a couple of requirements. First of all, the impediment could not have been foreseeable at the time of the contract. It was not reasonably foreseeable at the time of the contract. Second, the impediment had to be unavoidable, meaning there's nothing that one party or the other could have done to prevent the impediment from taking place. And finally, there's a notice requirement. The breaching party must give notice to the other party of the impediment and what its effect will be on the contract. So those are the three requirements to establish impediment beyond control. And the importance of impediment beyond control is that it is sufficient excuse for failing to perform according to a contract. The other excuse for non-performance we want to talk about is force majeure. Now, force majeure is a term that means superior force, and it operates much like the notion of impediment beyond control, that in fact there was something that was outside of the party's control that prevented the performance of the contract. Now, force majeure tends to be things related to wars, enemies, strikes, or severe strikes, acts of God, earthquakes, hurricanes, tornadoes. But what happens is that lawyers will usually include language in the contract, and that language is referred to as a force majeure clause. And what it says is that if there is a force majeure, the parties to the contract will not have to perform. On the occurrence of one of the force majeure situations, and again, war, blockade, fire, strike, in any of those situations, the party is excused from performance. Now, the reason that lawyers use the force majeure clause rather than relying on CISG Article of impediments beyond control is that the force majeure clause is actually part of the contract. So it's not really a legal excuse for not to perform. Instead, it's non-performance based on the contract. So you don't breach an agreement when you fail to perform because of a force majeure. Instead, you are following the agreement by failing to perform when a force majeure has occurred. So in any international business transaction that you or your company is involved with, you should be sure to include some sort of standard language relating to force majeure, because force majeure clause means you have a contractual basis for not performing. You don't have to prove up the elements of impediments beyond control. Instead, you can rely on the contract itself to give you an excuse for non-performance.